My name's Christy Miller and I'm joined here today by Hilary Searing and Shane McCartney, and we are the partners from the Workplace Relations, Employment and Safety team here in Brisbane. Now, and what we're talking to our clients a lot about at the moment is how to assist them understand the very quickly changing landscape in which business now must operate, how to meet an increasing regulatory burden, and whether there are any options to address or curtail significant labour market forces, including upwards wages pressure and productivity issues. Unfortunately, there is no one easy solution. If there was, we wouldn't need the Jobs Summit coming up, would we? No one solution, and the options for business, I think, really need to be tailored to an individual size basis, taking into consideration your industry, union presence, and a range of other factors. But we can't go straight into the answers. We can't do all the work for you. We're going to be using the Mentimeter today. We want to get your feedback as part of this process as to what is really affecting your business at this time, and make sure that we can guide this presentation appropriately and engage in a conversation with you. And I will say as well that if you want to ask questions during the presentation, if there is something that we've touched on that is of relevance and significance that you'd like us to delve further into, I'll pass quickly to Shay so she can go through the extreme detail on whatever those matters are. But please do feel free to ask questions. We want to make this as conversational as a room like this can be, but also want to make sure that it really meets your needs. So in terms of how we're going to run it today, the Mentimeter, perhaps if we just go to the first slide. This is how it works. If you want to navigate to that website, take out your mobile phones. That's the first and only time you'll hear someone say that in a presentation. Take out your mobile phones, go to the Menti website and enter the code.
Candy Crush.
And enter the code, and if you go to the website and then enter the code, it'll come up with the questions that we're posing as part of this presentation. We might go to the first question, actually. Have we got that information?
It's on each side.
Oh, okay. Perfect. Yes. Not working? No? Okay. So help us help you. What do you see as the most significant factor affecting the labour market at the moment? And you can vote. You can vote for any of those. Anthony, you can vote for other. I know you're going to do something funny there.
And you can vote more than once if you need.
But these are some of the things that we are seeing and hearing from our clients that are affecting their ability to properly engage with staff and move through these market pressures. And while we wait, we're getting some answers. Good. I'll let Hilary tell me what the answers are. But working out what the best strategy is we'll need to take into consideration what are the factors affecting your particular business. And I think then the starting point is to determine what is the government doing about these issues, and can we take any leads from the government? Can we piece together the clues that the government is giving us in terms of the changes to legislation, and can we preempt some of those and get on the front foot with those changes?
Skills 22 for skills shortages.
Yeah. And again, thank God for that Job Summit coming up. They're going to answer all of those questions. And bargaining. And bargaining is one of the big issues that we're going to talk about, and it will come out in the Jobs Summit as well. Hopefully, it's a bit of a dark horse underlier. Okay. And so we need to think about each of these individual issues. When we think about the government positioning and how they're going to address all of these matters, one of the, I think, important things and the early indicators that we saw was that when the previous coalition government, they made a real statement when they moved the IR portfolio in with the Attorney General's Department. I think they were really signalling to business there that they were taking an enforcement and a compliance approach to IR and to wages and labour. However, one of the first machinery of government changes that was made by the Albanese government was to recreate the Department of Employment and Workplace Relations as a standalone entity. And at the helm of that department, they've put Ms Natalie James. Now, Ms James was a former Fair Work Ombudsman herself. She was, at a previous time, the Chief Counsel of the previous iterations of the Department of Employment and Workplace Relations. And I think what this is saying is that they are looking at IR and the management of labour as a solution to these issues. They see it as a standalone issue and something that can be a remedy and a solution. I think it also signals the desire of the government to move very quickly through changes in this space. They've already introduced some legislation, and they have already indicated that coming out of the Jobs Summit, there are further changes to be made. And what are those changes? I think one of the things when we're thinking about how to navigate the problems that the labour market is seeing, we need to, as I said, take that lead from government and see what they're doing. The first bill that they have introduced is one creating a new statutory body called Jobs and Skills Australia. Now, not so inventive, the title, but that's all right. We get the idea of what they're going to do. That new statutory body is going to sit within the Department of the Employment and Workplace Relations. It is designed to provide independent advice to the Minister on emerging labour market issues, training opportunities and workforce skills in order to improve employment opportunities. Hand in hand with this, as I've already mentioned, is the upcoming Job Skills Summit, which has both been mooted as the hot ticket in town and also roundly criticised as a PR exercise gone wrong and simply a rubber stamp for what the Labor government and union movement, their demands. I don't know. I don't think we can be that quick to dismiss it. And I think one of the keys is that we all need to be taking some really early indicators from what the discussion points are at the Job Summit, which is due to take place on the 1st and 2nd of September. I think this is going to be, this is the time and the ability of these parties, both representatives of business and the union movement, to come together to really try and agree on some key or fundamental changes, and also to address issues like migration, and Hillary will come to that as part of the skills shortage solution package. The summit is also intended to address bargaining, and this is where I think there is a real room for some of the parties who attend the summit to come together. There are some concerns that not a lot can be achieved in 2 days, and I think that's a real reality. Another concern that is going to probably prevent real progress being made is concern within the employer groups as to whether there can be agreement even on that side of the fence. You might recall the previous Job Summit that was hosted by the coalition government, where there was a disagreement between some of the employer groups, actually, when the BCA made some agreements with the ACTU in relation to the softening of the boot test. Now, probably extremely necessary at the time. It wasn't roundly supported, and there was a real disconnect there, I think. So this is the opportunity, I think, for those groups to really come with a cohesive position to the Job Summit and give us some early indicators of what those changes might be. The government has already flagged that changes or proposals put as part of the Job Summit will make their way into the October budget. So I think that's a real reality. There's a white paper planned on employment issues that is flagged to be released in early next year. So any issues coming out of this Job Summit will really influence what the government takes on as their agenda, in addition to the policies that they've already released. So there's a notable tension between the parties who will be attending the Job Summit. There's a limit on time given as part of this process. I think they'll go straight to bargaining as a particular issue that needs to be addressed. It should be a real focus for them. And so if we think about bargaining, if we move, can we go to the next one? If we think about how we're bargaining now, for those of us in the room that have to engage with the enterprise bargaining process, where are the impacts that you're seeing in bargaining? Is there delays? Is it the return of the ambit claims? Are we seeing that reduction rather than improvement in flexibility? Are we not seeing, for the increased wage demands, that productivity gain as well? I'll definitely transition there to Shay, who's going to take us through the impacts of bargaining and the importance of getting that bargaining right as simply one part of that, as I say, that broader overarching puzzle.
Thank you. Thank you, Christy. So, as Christy said, we haven't really heard, I was worried that it was me making that noise. We haven't really heard a lot about what is going to happen in terms of bargaining, and there are only some sort of broad platforms. But as Chrissy said, very important to see what comes out of the Job Summit. We did, of course, have a Job Summit-like attempt at getting consensus as to what bargaining should look like. And I should say there is consensus between the parties and I think industry and the unions, which is that bargaining is broken. It's just that everyone can't quite agree as to why it's broken and how it should be fixed. But otherwise, we are all at least in agreement that it's broken. Currently, something like 11% of private sector organisations still have enterprise agreements. So if you think about most organisations, therefore, have either moved away from enterprise agreements and moved towards either increased flexibility in the modern awards, individual agreements, or other alternatives outside of employment, like contractors, gig economy, etc. This is obviously a key platform of the Labor government. It's one of its prime purposes. For those in the last session, we know that purpose is all important, and of course what sits behind the Labor Party is a desire or a belief in collective bargaining. So we are likely to see a push back towards bargaining. It's interesting to see the delay to commencement of bargaining or no progress in bargaining, because of course anyone who has been involved in bargaining in historic times under a Labor government will know that bargaining is likely to get harder, or at least have greater pressures on employers. So what can we do now is get an agreement, and get an agreement quickly, and what we're seeing is that pushback against that by the unions. But this point in the middle, which is the reduction rather than improvement in flexibility, I think is the most critical one, because the cost of getting an agreement is not worth what you achieve. And that's, if there's little risk of industrial action, that's really, for most employers, all that they're actually achieving in their enterprise agreements. So what is it likely to look like, or what are the changes? There was discussion around multi-employer agreements. That wasn't well formulated, and there was, pattern bargaining might be another name for it, but we wouldn't call it that. But that's something that we expect is likely out of the Job Summit, to get some clarity as to what that might look like, whether that's industry bargaining or whether that's just companies in a like field. The increase in good faith, so bargaining in good faith, I'm not sure if anyone noticed, but there is actually a good faith bargaining obligation in the Fair Work Act as it currently stands. But there is a suggestion that we'll move towards good faith bargaining. What you can assume that means is an increase in what good faith bargaining looks like, and an increase in the ability for the Commission to intervene or get involved in disputes. And again, the Commission already has pretty strong powers in that regard, so one would expect that to increase it probably really increases the rights to arbitration, rather than currently a lot of the powers sit around issuing directions, conciliation, etc.
And I'd say that would work hand in hand with the comments that we've already seen from Burke as the Minister, that he's going to move away from this ability to terminate current agreements that aren't working for parties. So if they remove the ability to terminate agreements, coupled with your comment around the increased prospect that the Commission will be involved in bargaining and move to arbitration, I think that's a scary combination.
And then combined with that ability to prevent unilateral terminations is also the ability to terminate any work choices agreements. So organisations who are sitting there on old agreements, or zombie agreements, which have served them well because they override the award, they otherwise let them carry on their business, can expect that those agreements may be brought to an end. The other significant change being proposed is genuinely representative, agreements only approved by genuinely representative cohorts. And so this is a move away from, small cohort agreements, as they're calling them, where, you might have a few people that agree to an agreement that then is later on to cover a broad number of people. Again, we have scoping provisions in the Fair Work Act already, so you would expect that what we're going to see is stronger changes to make the Commission to have abilities to decide whether the group is actually representative rather than just genuinely chosen. So it's all very well, Hillary, to talk about what we're going to pay our, that was just to make sure you're paying attention.
Totally.
It's all very well to talk about what are we going to pay our employees and how we're going to get agreement with them. But where is this labour coming from? And we had, I think, 32 people
26
say,
is when I stopped counting.
yeah. Say that skills shortage is the primary issue. How is the government going to change that?
That's a good point, Shay, and I think obviously everyone can start filling in their thoughts on how that's going to go, but this is, I think, going to be one of the critical aspects that's going to be dealt with at the Jobs Summit that Christy has been mentioning. We're currently sitting in Australia on the highest inflation rate that's been recorded since 1990. So we're currently sitting at 6.1% inflation, and the economists are predicting that that's not at its peak yet, that we're actually heading to a peak later in October and early January, and that they're looking at that's going to be about sort of 7.75% or 8%. And then they're predicting it's going to press, yes, good point. And then it's going to hopefully come down and continue to drop until 2024. But inflation in the UK and the US at the moment is sitting at 9.4%, 9.1%. People are talking about the impact that is going to have on the global economy, and talking about the high risk of recession in the UK and in the US and in Europe. The Australian economy, we're in a very strange situation at the moment. I don't know that we've ever been in a situation like this at the moment, where we've had a combination, I think, of changes to both demand and supply chain issues. So we've had the demand increase because I think of COVID and everyone's been locked down at home, and so we've had this real increased consumer spend on things that people wouldn't normally be buying. People often spend a lot of money on travel and other things, but we're seeing people doing renovations, we're seeing the public transport, people not really wanting to catch that so much, we're seeing cars and everything being bought. And all of these things have then been coupled with a real crisis in terms of our supply chain, the global supply chain and in Australia. And that is a very unique situation where with these combination of demand and supply changes have led to the inflationary situation we're in at the moment. We also have massive labour shortages here in Australia, which I think everyone has sort of picked up on in terms of really focusing on that skills shortage and what does that look like for Australia. We're talking about, they said a third of businesses at the moment are struggling to find workers. We have, at the moment, one of the highest rates of employment that Australia's ever had. And this potential high inflationary environment and this upward increase on wages, but at the same time, we're having concerns about productivity and gains. So and we're also having illness impacting. I think the Qantas CEO, Alan Joyce, said that they were budgeting at the moment on 50% of their workforce being on personal leave at any one given time, at this point in time. So we're sort of kind of having a bit of a perfect storm. We've had New South Wales and the Victorian premiers calling for more skilled workers and more skilled migrants to come in. And we've had I think this is going to be a key issue that comes up at the Job Summit. I think productivity, bargaining and immigration are going to be top of the agenda. And
we do know that Alan Joyce is one of the few people already invited to the Job Summit. So
good. Well, I reckon he's going to be hitting that hard.
Does that mean that my invitation is
you are not invited?
I'm not coming. I thought it was still in the mail.
So this is obviously going to be a critical piece, because I think if Australia runs the risk of falling behind, I think, the rest of the world in terms of our seeking out of this skilled workforce. There's been a lot of commentary in the papers recently about the fact that our visa system is really difficult and complicated, and as an immigrant, I can attest to that. So, you know, it's not easy for people to navigate it. I think they said there were something like over 300 categories of visas with subcategories and strict rules and compliance. So the unions have come to the table, and the ACTU said it's prepared to support immigration as a solution to this skilled shortage, but they've put in conditions on it. They're saying that we're prepared to support immigration if we change the threshold of the wages that are being paid to migrants, if we make sure that there's sufficient protections in place for the migrant workers, but then also, again, I think to protect the Australian workers and the Australian economy. And I think we sort of have this situation where business is also then saying there are already protections in place. So I don't think that we're going to find a sort of magical solution very quickly to this immigration issue and to the skilled shortages issue, which again is to how are we actually going to deal with this skilled shortage. And productivity and efficiency, Albanese has said that the summit has to focus on that so that wages are not eaten up by inflation, and that current worker shortages are both inflationary and a constraint on growth and productivity. And I don't think we're going to solve that very shortly. So I'm going to go to the next Menti slide and say, what do we think is the most significant impediment to productivity increases here? How are we going to deal with these problems in our organisations? Because I don't think immigration is going to be a quick fix. I'm going to hand over to Shay to talk about what are some of our barriers to increasing productivity still in the pandemic world that we're living in.
And I think some of the answers came up on that previous slide.
We should go back.
So flexibility is obviously one of the key issues, and it's a double-edged sword when it comes to productivity, because while it can unlock and empower organisations to be able to do more, and certainly during COVID, if an organisation didn't have flexibility, then its productivity tanked. And if I look at somewhere like Clayton Utes, I mean, and even if I look at the practice groups within Clayton Utes, the employment team, you know, because we go out on site, because we have flexible work practices, we have a very diverse group that have, you know, lots of different ways of working. We were already set up to be working flexibly, and we really didn't miss a beat when it came to, a little panic, but you know, in terms of, you know, from day one to day two, we continued on as if we didn't. Other groups, though, that were set up, you know, all with big folders and everything, you know, we're already paperless, we're amazing.
Some of us are paperless.
Some of us are more paperless than others. But so flexibility becomes that key driver and can be a key driver. It can, of course, also, though, be a key problem when it comes to productivity, and we're seeing many organisations now trying to rein back in some of that flexibility. We did see, you know, Elon Musk threatening that all of their executives were going to be sacked if they didn't come into the office on the next day. I didn't get to find out how many of them were actually sacked, but we certainly are seeing organisations that are struggling with unsophisticated flexibility models and not able to create those productivity gains because they're not having those touch points with workers. And we discussed a bit of that in our last session around if you can't engage and communicate and drive towards the same purpose, then your productivity levels tank.
We'll let them answer the question. Do you want to go to that? Oh, sorry. I'll just rectify you.
So if we look at then what are the most significant impediments, I think one of the areas where Labor policy can have a significant impact is the way in which we engage people. And we've seen the courts create significant change in this regard with the personnel contracting case, and we thought we had provided or settled once and for all these issues of whether or not if you set up a contractual arrangement that looks like one thing, and if you've all agreed and it's in the contract and the contract is valid and binding, then effectively the contract is king. And personnel contracting said that, you know, the multi-factor test effectively is only relevant so far as determining if you have a contract, a written contract, then the multi-factor test is relevant to determine whether what that written contract looks like is actually an independent contracting arrangement. So we all went, okay, well, we get that. But then the Labor government has said, particularly with respect to the casualisation point, that's not right, that effectively we need to go back to, and has also raised concerns with the legislative changes that were made to give clarity in relation to casualisation, and said that that's unfair effectively, and that it allows for employers to call someone a casual when they're not effectively a casual, and that the security of employment is a key platform for the Labor government, and therefore they'll be legislating to first of all go back to the common law test as to who is a casual, which ultimately in most of the businesses I deal with, people don't really care what the test is, they just want to know the test. Like, casualisation is not necessarily a big problem in organisations. Most of them have a good understanding. They just want certainty, because what they don't want is an underpayment of wages issue. And when we look at bargaining, and we look at these issues in relation to changes for terms and conditions of employees, of course, one of the big things that organisations struggle with is that the risk of underpayments becomes, and one of the key platforms is to make wage theft a criminal offence, and to be able to prosecute officers of an organisation where there are deliberate wage theft. So it's a big issue for organisations if they get it wrong, and we see that reputationally, we see that legally. So I don't think that employers really mind one way or the other what the test is. I think they just want certainty, and going back to the common law test is not going to create certainty, but that's what we're looking at. And then when we look at what else do organisations use to be able to try and address the skills shortage, to address the impediments to productivity, because of course if we don't have enough labour, then we're not productive, then, you know, the whole economy suffers, is the use of labour hire and contracting arrangements. And what the Labor government is saying is that they will, again, security of employment is king. And so same job, same pay. If you're a labour hire company and you're coming onto, and they particularly mention mine sites where labour hire come on and work side by side with full-time or permanent employees, then they should have the same terms and conditions of those full-time and permanent employees. And so that's going to have significant impacts on how we organise our businesses. And if we combine that with, so you would have seen just this week, always love a full federal court decision the day before you're going to give a presentation on exactly that issue, but we had the decision come down in relation to Franco and Deliveroo that upheld that the delivery driver was not an employee. But in the case, the full federal court said that this was they didn't use the word tragedy, but they said it was a very unfortunate situation. They said, regrettably, this leaves Mr Franco with no remedy he can obtain from the Fair Work Commission for what has plainly, in our view, been an unfair treatment on the part of Deliveroo. And they effectively called for legislative change in terms of the gig economy. And when I say the gig economy, whilst it impacts significantly, obviously, on that economy, the proposed new jurisdiction to deal with employment-like arrangements has the potential to go much further than that, because things like independent contractor arrangements, as we said, labour hire, even where you're seconding people into from one, the odd co-type arrangements, are all likely to be caught up in this ability to regulate what is otherwise not employment type relationships. Now, this may increase productivity, because what we might see is that we get certainty in that industry and it therefore is all regulated, and but the reality is that often with more regulation becomes further restrictions. And I think particularly for organisations, they have to think very carefully now about what are the benefits they get from these alternative type arrangements, because we know from a safety perspective that often you're held accountable in any event. Often what you got was a cost benefit. If that's not there, then we have to look about whether these are the right types of arrangements to continue forward. So we did want to ask quickly, what type of workforce do you have, and do you think that these types of issues are going to be a problem for you? I think I already covered this topic as well. The other aspect in terms of the fixed term contracting that's proposed is to limit fixed term contracts to no more than two terms of a fixed term contract, and for no more than 24 months. So again, really limiting these options that organisations might use. Now, that was probably always the case, that if you had more than 2 contracts in a row, you're probably running a risk that it was no longer an appropriate arrangement. But they're going to, again, regulate in these types of organisations. So no one cares, because they're all for full-time employees in any event. So with that, we will move swiftly on to when we look at the casualisation, the flexibility of workplaces. With that came, I guess, increased focus on how we deal with our workers. And if I look at the respective work, and I'll hand over to Christy to talk about how that has.
Yeah, so this is another big regulatory change that's both come and is still on the horizon for us. So to catch us up in this space while we see what you think the risks are in this area for your business, the federal government has now committed to implementing all of the recommendations from the Respect at Work report. Some are already done and they're in, but the big one yet to come is the introduction of a positive duty on employers to prevent sexual harassment in the workplace. And the federal government has now committed $35 million over the next 4 years to both implementing the legislation and putting in place programs to ensure that it can be monitored, enforced, assessed. But don't worry, that's not all you have to deal with. In Queensland, we're going through exactly the same thing. So the Anti-Discrimination Act has been up for review recently, and a report has been prepared by the Queensland Human Rights Commission. It has now been provided to the government and will be tabled in Parliament, I think, next week. And after that, it will be published. And one of the big matters that it was considering and calling for submissions on is the potential to introduce this positive duty to prevent discrimination in the workplace. So what does this mean? Now, you might already have a lot of processes and policies in place that will assist you meet this new regulatory burden, because what we already have under our work health and safety legislation is a positive duty to prevent and to guard and protect the safety of our workers. And that extends to bullying and harassment in the workplace. It's not as often used by the regulators, but it is certainly there. They are getting ready, and they're coming in with the 1-2 punch. So the safety regulators are getting ready, and will then be coupled with the extra regulatory framework in both the discrimination legislation federally and at a state level. And in terms of what we're seeing the risks are, organisational culture,
Leadership. 1-for-1 at the moment.
Yeah, and I think that's going to be a big issue if we don't have the leadership to lead these changes, because I do think that business needs to make change to accommodate the Respect at Work changes and the changes that we'll see at a state-based level. if this is not a top-down process, I think we're going to have a lot of trouble with buy-in, we're going to have a lot of trouble with enforcement, and then we're not going to have the documentation and that paper trail there to be able to show to the regulator when they come knocking on our door. Yes, we do have the processes in place. Yes, we do assess and monitor the work environment. Yes, we can demonstrate that we are taking active steps to prevent sexual harassment and discrimination in our workplace. So if those are our concerns, then I think we need to start implementing now some changes in our workplaces so we can try and alleviate some of those problems. And so what do we do in that case? Because the test, if I'm reading the tea leaves right, is going to be that we need to take reasonable and proportionate steps equal to the size of our business to meet this new hurdle. And we're going to need to maintain evidence to demonstrate that those steps, what we've taken. So that's going to include risk assessments, I think, making sure that we've reviewed the workplace. Are we undertaking surveys in our workplace to assess and understand what our staff consider to be the risk of discrimination or harassment in the workplace? And if we are doing those surveys, can we demonstrate that we've taken steps to address the outcome of those surveys? Victoria have already implemented a positive duty to prevent discrimination and harassment in the workplace, and they have provided some guidance on what it looks like to meet that positive obligation. And they said it's different, as we understand it will be, for large versus small employers. And they give an example as part of their legislation about a large employer, and they conducted a staff survey, a confidential staff survey, that revealed women were uncomfortable with the level of sexual banter in the workplace, but that their grievances were not treated seriously or confidentially. As a result, what the Commission in Victoria said was that this employer needed to review their policies and provide training for all staff on the rights and responsibilities. By contrast, they said that a smaller employer may have had the same obligations to conduct the staff survey, but depending upon the outcomes of that staff survey, there may have been different obligations in relation to the training that is implemented. Now, I think what they're setting out there is a very light touch approach, and maybe that's not going to be sufficient in all circumstances, but it's going to be very difficult to know where that line is and what is the appropriate steps. So when we're preparing for this change and when we're thinking about our culture and the understanding within the organisation of the rules and the requirements around sexual harassment and discrimination, I think that's where we start. We start building that understanding at a workplace level. We start setting the tone in terms of what is acceptable or not acceptable in the workplace, and this is where we need to engage, obviously, with our boards and make sure that we have that top-down, and we have those risk assessments in place that identify where those real trigger points or those concerning areas are. And we really need to be able and ready to meet this new, more regulatory change. I feel that's all I'm saying these days. There's regulatory change and we've got to meet it.
New, but not so new.
And as I said, I think it will require a whole of company response from the board level down. But the regulatory pressure is not just being felt here in this respect at work or the discrimination space. The work health and safety laws are also up for review in Queensland. And this continues to be a huge challenge for business. And I think if we move to the next slide, I think, Hilary, we'll get you to talk about, and maybe while Hilary starts talking about the safety aspects of business management and how this will impact your overall business strategy, have a think about what your safety concerns are or the risks and concerns that you see from that safety management perspective to your organisations.
I'm very concerned that only 2 people thought that safety was a significant issue in their business at the moment. So we'll take you all out. And Brett was one of the 2. Well done, Brett. Trained him well.
Thanks, Christy. Thanks, Shay. So as Christy mentioned, just last week they actually announced a review into the Queensland workplace health and safety legislation, and in particular what they're reviewing and having a heavy focus on is the industrial manslaughter provisions and whether they are effective and they're working as intended. I'm sure you'll all recall that the Queensland introduction of the industrial manslaughter provisions in 2017 actually led to the introduction of industrial manslaughter provisions provisions across a number of states and territories in Australia, and I think currently we have it in the ACT, the Northern Territory, Victoria and WA. South Australia, with a change in government, has recently announced that they will also be introducing the industrial manslaughter provisions, and the Commonwealth, with the election of the Labor government, has also said that they will be amending the WHS legislation to introduce the industrial manslaughter provisions at a Commonwealth level. So that...
And New South Wales is now using their manslaughter legislation to show that they didn't need to change it because they could have always used it.
Yes, they've just... so New South Wales has actually amended their act to put a little note in there to make it clear to anyone, apparently, if you didn't realise, that if a worker dies at work, it can be prosecuted as a crime under their criminal legislation. And actually just last week they've recently charged someone with the workplace manslaughter of a person who was struck by a forklift, and so that matter's going ahead, I think, under the... It's always a forklift. They're very concerning. I have some forklift matters on at the moment, which very dangerous plant. So they're having that as... and of course here in Queensland we've had a number of prosecutions actually occur for the industrial manslaughter provisions. I think just in March this year up in Gympie we had a person he was actually the PCBU because he was a sole trader, found and convicted guilty of manslaughter, of industrial manslaughter, and he's been jailed. So up here in Queensland, so they're doing that review. And said, Minister Grace has said that given 5 years has passed since the previous best practice review, which introduced the industrial manslaughter provisions, it was time to ensure that Queensland's laws remain robust, effective and enforceable. Coupled with that, we've obviously seen a raft of recent changes. Now, the WHS legislation has been relatively, there hasn't been a lot of prosecutions, there hasn't been a lot of case law in terms of some of the Category 1 offences and things, but it's been quite stable since 2011, since the big changes. But recently we've seen a raft of changes occur in the WHS legislation. So in June, they introduced a number of amendments in the Commonwealth legislation, and one of those was to make a category to add gross negligence as a fault element to the Category 1 offences, because previously you could only be charged with that if you were found to have been reckless conduct. So that was, apparently the prosecutors have been finding it too hard to convict people, so we're actually, they have amended that in the Commonwealth. The other things that they have done is they're prohibiting insurance against WHS penalties. Now that's a change that had already been made in New South Wales and WA. It's now a change that's been brought in the Commonwealth legislation, and it's one of the recommendations of the Marie Boland review, which was to make sure that organisations are feeling the sting of the safety penalties, so that if you can get insurance against it and not have to really feel a sting in your organisation, the concern was that the penalties won't have the impact and drive the cultural and safety changes that they want. So they're actually now making it an offence to even for the insurance companies to offer it, and for the organisations to enter into that insurance in the WHS space. So that, I think, is going to be a big change for a number of organisations. So in terms of some of the other amendments, the Labor government has, since coming into power, talked about some potential changes that they're going to be bringing in. So I think they've got a very full agenda. They're talking about bringing in some of these amendments to the Fair Work Act and the other provisions in the spring sitting of Parliament. I did ask which spring, because we're pretty much there. And so they were also talking about bringing in amendments to the WHS legislation. Now, whether that's actually going to happen or not is a moving piece, but indicated they're going to do that. And some of the amendments that they're proposing are quite far-reaching. So they're talking about changing the onus of proof in the WHS Act and bringing in a reverse onus of proof. Now, I'm sure some of you may recall, prior to the 2011 changes in Queensland and in New South Wales in particular, there used to be a reverse onus of proof. So the prosecutors would simply have to allege the offence, and then the person would have to prove that they hadn't contravened the Act. But one of the reasons that you did that was by proving that you'd taken reasonably practicable steps. Now, the legislation got changed in 2011, and that was one of the main things they looked at in that review, was whether that it was appropriate to actually have a reverse onus of proof in what is effectively a criminal charge. And they found that it wasn't, and they brought in the reasonably practicable defence into the Act and left the onus of proof, changed the onus of proof to where we're currently familiar with it now. The government, the Labor government in the Commonwealth has said that they wanted to bring in all of Marie Boland's recommendations, even the ones that weren't implemented by the coalition. But interestingly, she didn't actually recommend this. Marie Boland looked at it and said that with her recommendation to introduce industrial manslaughter, to increase the fines that were being put to increase the sort of category 1 offences, she carefully looked at that reverse onus of proof and said that she thought it was appropriate that it remain where it is, and that the prosecutor then has the burden of proving that the PCBU or whoever has been charged has actually breached the Act beyond a reasonable doubt. That the government, the coalition, Labor government, is talking about changing that. They're also talking about giving prosecution rights to the unions and to workers, which again I think is quite an interesting development. And I mean, I think you can imagine a family who's had a fatality of their beloved family member. I think there would be a real increased drive for that person or that family to want to bring a prosecution and to see, justice being done. Which, obviously there's a lot of careful consideration that goes into whether or not a prosecution is actually brought. And we're also seeing them talking about increased funding, giving these regulatory bodies an enormous amount of funding to help with some of these things. So, look, I don't know what's going to happen in this spring sitting and where we're going to end up, but...
But with the Labor government in each state, usually, in the majority of states, you'd expect that there's likely to be toeing the line in terms of those changes.
Correct. So if we could go to the next. So I think obviously that's quite a lot of things that we've talked about here today. We've talked about some of those big increases in risk in terms of the respect at work changes and what that might look like for your organisation. We're talking about wholesale reviews of the WHS Act and really potential very onerous changes on that reverse onus provisions. We're looking at the job summit and what's going to come from that, and casualisation, and what does that all mean for your workforce. So in terms of that, immigration options, yes. What advice would you give business? What do we think?
Is that they should emigrate to another country?
I think someone
or bringing people in.
I think we're immigrating out. So I mean, maybe we all need a stiff drink at lunch. But so from that, I thought I might hand over to Christy and Shay and sort of give ask you to give one top tip on what you think, what advice you think business should do and help with planning for the next 3 years. And just to give you a second, I'll give you my hot tip in terms of which is not going to be anything that we haven't said already.
You just wanted to go first. So
I do, yeah, that's
correct.
That's exactly right. Which is really... somebody's already talked about here being taking care of your people and doing the right thing. I think a huge part of the WHS changes that are coming in is getting your corporate governance right and being able to demonstrate when the regulator does come knocking, if they come knocking, that you have your safety systems and processes in place, and how are you taking these steps to manage that people. And if a reverse onus comes in, I can just see that becoming increasingly important. Who wants to go first?
I like instruct Clayton Utes to provide advice. I think that the person who wrote that was very clever and should be commended. For me, I think there's two. Am I allowed 2 top tips?
Yes.
Many
as you like.
And not only that, but I think I'm stealing Christy's. I hope not. But lifting these things up to the board level, is that what you were going to say? It was. Sorry.
No, that's right.
That's
right.
But
even you one.
When I look at particularly the enterprise bargaining aspects, those changes of themselves might seem simple, but all of the elements that we've spoken about are going to be folded back into increased industrial disputation, increased use of the commission, increased regulation, and the implications of these things are now much more far-reaching than simply setting of wages. And so they do need to be elevated to an executive and board level, and as we were talking about earlier on, if the information's not coming up, that's when you have a problem. So setting your systems in a way that there is proper reporting and proper communication flow, so that the executive know, that these things need to be looked at. And then the second one is the risk assessment, which is what I thought you were going to say. But once again, first of all, actually looking at your strategy, understanding what the risks are and assessing those risks is critical. But then documenting that risk assessment so that when you are looking at each of these things, and whether it's underpayment of wages, if you've got a risk assessment that identifies how wages might be underpaid, and that then puts in place appropriate measures to ensure that there is no underpayments or no breaches of the legislation. If there's a prosecution, it's going to be it's not going to be wage theft, it's going to be an inadvertence. It applies in a safety respect, it applies in a sexual harassment respect. Actually doing proper risk assessments on the organisational risks is critical.
Well, I need 2 as well then. Everyone gets 2.
You can have 3 if you want.
I'm not going 3. And one's an immediate tip and one's sort of future focus. So immediately. Keep an eye on the outcome of the Job Summit. I think next week it'll be really interesting to see what the ideas are that are floated, some of which we already know around the boot test and bargaining. But this is our chance to try and understand that and maybe try and take some of those ideas back and implement them in the business, even if they aren't as agreements reached. We know that they're going to form part of the October budget, the white paper on employment that the government will release next year. So keep that in mind. And similar to Shay's point, I think get ahead of that regulatory burden. We know that the positive duty in relation to preventing sexual harassment and discrimination in the workplace isn't in yet. It's going to be. You know, they're all still considering it. I can bet you 10 to nothing it is coming in. It's definitely coming in federally, and I can bet you that the decision of the Queensland government will be to introduce it as well. So get ahead of that regulatory curve. We know what we need to do. Risk assessments, Shay said, is where you start, but check your policies and procedures. You noted that one of the issues was around the organisational understanding or the leadership piece around these matters. Start focusing on that now while there is no prosecution potential for it. And that's about taking care of your people as well and doing the right thing. That will set you up, I think, not only to meet your regulatory obligations, but to create an environment in where people want to stay. We have less skills slippage and loss of employees, and hopefully can start turning the dial on some of those things. So they're my 2 takeaway tips.
Now, who would like a copy of the slides? Would you like us to send them out? Yeah.
We can do that.
That is what we will give you from today. And
Okay.
a glass of wine.
Well, thank you everyone for coming today. We've enjoyed your answers and seeing them pop up on the slides. We've had no questions. We are more than happy to take questions, and we'll certainly hang around too and join you for lunch. So thank you for your time.